Good morning, everyone. Welcome to the J&J Consulting Services Incorporated investor call for the first quarter of 2024. My name is Jeff Winkler. I am the court-appointed receiver for this case. I appreciate you all taking the time to join this call and give us an opportunity to walk through what is currently happening in the case. I know that we've seen a lot of questions come in, and we're going to do our best to answer those questions as we can. A couple disclaimers that you guys have heard in the past, and that is that anything I say in this call should not be construed as legal or accounting advice. If you have specific questions related to it, I recommend that you reach out to competent legal counsel or accounting CPA in order to get any advice you may need. The other thing I want to mention is that any party referenced in here is innocent until proven guilty, and nothing should be construed otherwise based on what I say. I appreciate you guys again taking the time to do this. As you recall, my role as a receiver is as a neutral fiduciary for the court in order to administer this case and help collect back as much money as possible and get that money back into the hands of investors as quickly as we can. The timeline again looks like we will continue to marshal assets and continuing our investigation while at the same time completing the forensic accounting. We are selling assets. Once the forensic accounting is wrapped up, we'll begin the claims process and look at doing distributions. At the same time, we will also be doing third-party litigation. We'll be dealing with tax-related issues, and then ultimately, like I said, getting money back into the hands of investors and closing the case. So that's the typical timeline. Usually these cases will take anywhere between 3 and 5 years. That can vary depending on the complexities of the case and some of the litigation involved. That doesn't mean that it'll be that long until you receive a first distribution, but it does mean that that case will likely go on for that amount of time. So I want to get into some of the general questions that were asked in the case, specifically, as it relates to different areas. The first one that we want to talk to is just kind of general questions. One of the questions asked is, what are some of the remaining tasks? Part of what we're doing right now is the forensic accounting. As a matter of fact, that's the largest part of what we're doing at this point. The forensic accounting serves multiple different purposes. The first of which is that it allows us to effectuate a claims process, whereas people who invested money in the company in this scheme will be allowed to make a claim for those monies and ultimately receive a distribution. The forensic accounting also does a couple other things. It, number one, shows us what assets were purchased with receivership assets, so then we can go back after and make sure that we've collected all those assets or learn about new assets. It also allows us to understand better what third parties may have liability for part of what has gone on in the scheme, including promoters, potentially net winning investors and other third-party professionals who helped further or perpetuate the scheme. So that forensic accounting is going to be key to that piece as well. So those processes will all be kind of working in conjunction with each other and going on all at the same time. Somebody asked a very specific question about the $2.8 million payment that went to JL2 investment repayment. So as part of my job as a receiver, we located an asset by the name of Eco Battery. It was made up of 3 different types of investments. There was a purchase of stock by one of the defendants. There was a promissory note investment by one of the defendants. And then there was a promissory note investment by 8 people who were not defendants or otherwise a part of the J&J Consulting case. And as part of what we did in that case in collecting back those promissory note payments with interest, part of what we collected was money that belonged to those 8 people who were not part of the J&J case. And therefore, the court gave us permission to pay those funds out to those parties because they didn't rightfully belong to the receivership estate. We just collected them as part of the process of collecting everything else. We are in the process of negotiating a final settlement on the equity, the ownership piece of it, the business, and we'll be recovering all the money that was invested into that company for the benefit of the receivership estate. If you have more questions about that information and the court order is available on our website for review. Next, let's talk about the defendants and the parties. People have specific questions about specific defendants and whether or not they're in jail or if they're going to be in jail. And all I can tell you is that we are working on the civil side of this case. So what we do has nothing to do with the criminal end of it. Now, we do know that Matt Beasley is currently in jail right now, awaiting his trial on his case. There are no other defendants charged as that I'm aware of at this time. However, We are not part of that case. That is done by the U.S. Attorney's Office and the Department of Justice. And so we will have to wait and see what it is that they ultimately decide to do in this case. Moving on to litigation. Question specifically about Wells Fargo. Is potential recovery with Wells Fargo completely separate from the Ponzi scheme, or is it considered partially what will make investors whole? The litigation against Wells Fargo, once complete, that money will go into the receivership estate and will be distributed out as part of the distribution process, which will be part of claims. What is the status of the Wells Fargo lawsuit? We actually had our second mediation session last week on Thursday. We were unable to settle the case at that time, but we do believe that progress was made. Unfortunately, anything that happens within the mediation is subject to the mediation privilege, and so we can't get into the details of exactly what happened. But just know that we are fighting hard for the investors and for the maximum recovery possible in that lawsuit. The questions like, has Wells Fargo offered a settlement? We did put some proposals on the table, but as I said, we were unable to settle it at that time. We will continue to do discovery-related work, including depositions of some of the parties, and we do believe that we will also be meeting again for future mediation. Assets. What is the projected total dollar amount of recovery? That number is unknown at this time. Currently we have about $65 million in cash in the bank. We do have a few other assets. We will continue to collect assets from defendants as well as other parties, in addition to the third-party litigation, including the case against Wells Fargo and other potential parties as well. How much money has been recovered so far? I think I just answered that question. Are you still discovering more money to go after? And the answer is yes. We discover more assets all the time as part of that, as part of the forensic accounting process, in addition to information that investors provide us either via telephone or via email. Every time we get that information, we will, of course, research it and go after any potential assets that we find there. There's some very specific questions about the percentage of funds recovered and things like that. Of course, it's impossible for us to say exactly what that percentage is going to be at the end of the case because there's still a lot of things that have to happen, including the claims process. We need to know what the total amount of claims is in order to be able to figure out what the percentage of recovery would be at that point. So let's talk about the forensic accounting. There is going to be a new questionnaire that is coming out to investors that we are going to be sending out this week that asks some very specific questions about how you invested in the J&J Consulting case. And specifically what we're trying to figure out is what we consider off-book transactions. So these aren't wires or checks that were deposited directly into the IOLTA account. These would be payments that went somewhere other than the IOLTA account. It could be via cash. It could be trading in of assets, whether it be gold, silver, other equivalents. Could be cars, things like that, as well as other investments made that were done on an investor-to-investor basis, where one investor might have bought out another investor, as opposed to waiting for the process to finish in the ordinary course of how it was working. The next question is, based on the bank records reviewed, what is the number of investment LLCs? That question I take to assume they mean the total number of investors, because not all investors did invest through LLCs, but the number did. That number, as we have reviewed, it looks like we're anticipating somewhere in the neighborhood of 1,300 to 1,500 investors that will have been involved in this case in total by the time we finish our process. When will the forensic accounting be completed? That is another tricky question, and just because we don't necessarily know what the end is yet. Every time we think we understand the known universe of accounts that we need to look at in order to complete this, we find more accounts. Of course, those additional accounts are good for investors because that, again, gives us an opportunity to find out more about what happened, as well as additional assets that we may not have known about early on, and will allow us to then go after those assets. Is the majority of the forensic accounting completed? And if not, why? So we have done all the largest bank accounts in this case, including the IOLTA account and some of the other very large accounts. But now we are going into some of the smaller accounts, or some of the accounts that we are unsure of what kind of information they contain, in order to then now look and try to tie out these transactions. Again, if the goal of this was just to figure out how much money came in and how much money went out as a whole, that would be a much easier process than figuring out who that money actually belongs to. And as we've stated in the past, there is no database of records where we know all the investors in this case and exactly how much money they put in or took out. And so that is our job to figure that out. And due to the fact now we're up over 650 bank accounts, covering in excess of a 5-year period of time, it is a very complex process. The good news is, though, is by the end of this process, it will make the claims piece of it much, much easier. We anticipate having to request a lot less information from investors. And so it should smooth out and make everything else easier, including the litigation against other third parties. By getting this forensic accounting done, complete and accurate, it will allow us to go through this process in the future the smoothest possible. And the next question is, why can't you allocate more resources to make the forensic accounting priority? The forensic accounting is our #1 priority by far, and we have allocated as many staff to that project as we think makes sense given what we need to be able to do. We have to be nimble in order to continue to make updates and changes to the information as we discover new things. If we get too many people involved in it, then it's going to be impossible to do that. And then we're going to have to continually go back over and make changes to the data. Whereas, the current way that we're doing it allows us to do it in real time. And so it is a much more beneficial process, much less open to error, and will allow us to ensure that things are done accurately and completely, which is the most important part of this. Currently, we have approximately 9 people that are working on it, to give you a reference as to how much that is going on. Let's see, the next question has to do with clawbacks. Are you going to go after people that were getting extra for bringing people in? So I can tell you, typically, yes, we will go after people who promoted the scheme and were paid commissions or false profits in these cases, which leads to the next question is, what are you doing if the net winning investors are staying quiet and not filling out any receivership questionnaires? We don't need them to fill out the questionnaire necessarily in order to know who they are and to know that they're a net winning investor. We will likely seek permission of the court and the SEC to go after net winning investors and ask them for a return of their profits. Since these profits were not legitimate profits to begin with, there was no actual operations, no actual profits being made, and therefore any money that were paid out as profits were actually monies that were brought in from other investors. Claims process. When are we going to get, or are we going to get our money back? The answer is yes, you are going to get your money back. The thing about the claims process and the distribution process that I want to point out up front is that those processes are subject to change in the way that we will do them. People want to say that we are going to do them a very specific way. However, as we go through this forensic accounting, it teaches us things about what this scheme was and how it was operating. And so that will allow us to then make potential changes to the recommendation to the court that we make based on what we learn. So the question of who gets priority, in a typical receivership case, investors are given priority over others. But until we finish this case out and understand what that means, we will not make a final determination on that. How would you notify the investors to claim their share of the loss? There's numerous different ways in which we will be doing that. First of all is through email, posting on the website. We will be publishing it in newspapers based on what the court authorizes us and requires us to do as part of that process. If you are signed up on the website to receive emails, you will receive multiple notices of it that way. If I use 2 separate accounts to fund my investment, when it comes to filling out a perfect claim, will I need to file 2 separate claims or just one claim? That is a technical question related to how we ultimately end up doing a claims process. But what is usual in that situation is that you would file one claim for that investment, no matter how that investment started. Next questions have to do with the distribution process. When will the first reimbursement occur? We will not be able to make the first payment until after the claims process is finished, because we need to make sure we understand the full group of people that are eligible for claims. Once that claims process is approved, we should be able to make a distribution very, very quickly. Once approved by the court, we have cash available to be able to do that, and we look forward to getting that money back into the hands of investors. Next question is, when payouts start, many investors think it should go to people that were last and then work their way back. Will that be the case? The way in which distribution will happen is unknown at this time, because again, we have to review everything that's happened in the past to make recommendations. Typically in a receivership, distributions occur on a money in, money out basis, where the funds available are distributed pro rata, meaning everybody gets an equal percentage based on the amount of their claim. However, none of that is set in stone at this time, as we still need to understand exactly what this process was and determine if that is the most equitable way to make a distribution. And then we will present what we feel is most equitable, or various options that we think is most equitable to the court, and the court will ultimately make that decision. And any interested party will have an opportunity um, to comment at that time. So the next question is, why aren't you doing distributions now? The simple answer is we don't want to give money to people who it doesn't belong to. So we need to make sure we understand who exactly is owed money in order to make sure that those people are the people that are getting the money, and that people who invested and got their money back already don't get money that they're not entitled to. I know you've said here's the next question. I know you've said in the past that when it comes to distributing money, you would give the same percentage to everyone, regardless of how much they'd already received previously. It just seems like there's so many people that bought into this recently who didn't receive anything or very little. Are you finished, or after you finish your findings, may the payout method possibly change? And the answer is yes, the payout method could change. And again, it's going to be based on what we think is most equitable given the circumstances of the case. How are you planning to distribute the funds to all the investor victims? If they're asking about the methodology, typically that is done via check. Although, with the technology nowadays, we're always looking at new avenues to potentially be able to do that. You're talking about the methodology of investment, whether it be on a pro rata or some other type of basis. That will be decided as we get closer, once we get into the claims process and we understand exactly how everybody lost their money. We will run some various different scenarios and present those to the court for ultimate approval. I'm going to go real quick to the chat and see if there's any questions that have popped up that we have not answered in here. I see that Anna has been answering questions as we've gone along. Thank you, Anna, for doing that. Let's see, when will the claims process start? How long will the forensic accounting take? The forensic accounting will be done this year. The question is, when will it be done this year? We anticipate, sometime between late summer and early fall that it will be done. And that is based on the information that we currently have. That could speed up, it could slow down based on some of the various different things that are happening. But that is our best guess as of this moment. Let's see, is there a comprehensive list that shows who's contributed funds or assets back to the receivership? There's some names I've never seen and claim that they have money sitting aside. So we do have a complete list of all the money that has been collected from the various different parties. That may be something that we will look to publish in the future if that's information that people want to know. Like I said, we have been setting money aside from various different defendants. And so we will work through that. But every time that we collect an asset, we say where it's come from and what the disposition is on it. We still have a few assets that we are holding on to that we are in the process of selling, including one home, a couple of vehicles, and some other miscellaneous personal property that we are selling. And so that will continue to happen as we move forward. We will also then be able to continue to collect assets from defendants at that time. Next question says, I thought we were up to 80 to 90 million in total recovered before, but this time it's 65 million in the bank. So the difference between the actual cash in the bank and the total amount of recovery has to do with the fact that there are assets that have not yet been sold, including a home, which has a pretty significant value. There are other homes that we have liens on. We're in the process of determining how we're going to move forward with those. And so the amount that we have versus the amount of cash that we have are going to be two different things until all of the assets have been liquidated and turned to cash, which will happen, over a period of time. Let's see, what assets remain to be sold and what is their approximate value? If you look at our last report, it does provide a list of the assets that are yet to be sold. The next piece of that, which kind of ties into it, is the recovery number has been 65 million for over 6 months. That is correct, again, because as we are collecting assets and the various different ways that we're dealing with them, not all of them have been liquidated, and some of them are in a current holding pattern until the SEC and the defendants come to some agreement as to what their restitution will be, and then that number will continue to grow at that point. Is there a reason to leave the claims registration forms open with no deadline? We have not actually started the claims process yet. Once the claims process starts, there will be a fast and rigid deadline to file. Typically, it's 90 days after the start of the process. And so you will see that will get taken care of at that point. What is the interplay with the private lawsuits naming Wells Fargo? So the private lawsuit and the lawsuit by the receiver have been merged into one case, and we are currently in the process of litigating that case together. And so there are a number of attorneys that are working on it, but it's based on one fee that will be split amongst all the parties, including my own counsel. Will there be clawback from all the investors who profited? Once we get permission to do so, we will do that. That is part of the part of the forensic accounting process. We have to know how much these people are, and we have to be able to prove it in a court of law. So again, that's another one of those things that is a key piece of why we do the forensic accounting the way we do it. If we were investors who made our only investment the week prior to Beasley's arrest, is there any realistic expectation that there will be funds remaining if we're the very last group of investors? So typically, when you invested is not going to have any say as to the amount of your claim. The only time that could come into account is when it comes to the distribution process. And that's going to be based on what the court agrees the way the distribution should be done. Sometimes the court thinks that there's a specific class of people who've gotten almost nothing back, and that there's another class of people that have gotten almost everything back. And in some of those circumstances, the court may suggest that the people who've gotten nothing back be paid a certain amount before others start getting distributions. But that is a complex calculation that has to be done and looked at by the court before that could ever be approved. I'm not suggesting that's the way it's going to be done, because we don't know ultimately the way it's going to be done, and we have to get further through this process before we can determine it. We need to know what it looks like if we do a distribution in a specific way. We need to know how that affects all the investors, so then we can make a judgment on based on what we think is best for the totality of everybody involved in the case. Let's see. There's a question about recovery and payment in full and getting paid back interest. Those are things that we don't concern ourselves with until after we get in a situation where we think that we will get to a point if there was 100% recovery. And to temper everyone's expectations, it's very rare in a receivership to get back 100% of the money that was lost, because people spend it in ways that are unrecoverable. They take vacations, they fly private jets. Now, with that being said, we're going to do our best to get back as much money as possible and to get back every penny possible. We're not going to leave anything on the table just because we don't usually get it. Doesn't mean we're not going to try to here. But we also have to be very smart with the money and make sure that we're not spending money to go after assets that are not recoverable, or that that we will end up even breaking even on. We need to do a cost benefit analysis to make sure that it's fair, that any money that we spend is money that is going to be recovered and recovered with some some extra room on top of it, because we don't want to just spend the money. That is not the goal in these cases. We really want to get back as much money into the hands of people as possible. People are commenting about the amount of the length of time that this takes. When we deal with these, keep in mind that there are due process rights of the individuals accused of doing things in this case. And because of that, things have to happen in a certain way over a certain time period. And so some of the things that happen in this case are just going to take a while because of those due process rights. And we are unfortunately, subject to that, because we all expect the same type of rights if something was to happen with us. And so that is going to slow down some of the things that happen in this case and make sure that things are done in a specific way. But just know that we are trying to get this done as quickly as possible. There is no incentive for us to continue to drag this out, because again, ultimately, we're going to be judged on how well we do in getting money back to the investors in this case. And so that is our ultimate priority, is to get back as much money as possible. Question has to do with Wells Fargo. If Wells Fargo is found to have any culpability, why couldn't punitive damage also prevail? Punitive damage are always an option that is available if we could prove that Wells Fargo was culpable in this case. To the extent that this case goes to trial, we will of course seek punitive damages, but that there's a lot of stuff that has to happen between now and then in order to be able to do that. Last comment here says, after our last call, you told the forensic accounting would be done by year end. Now it's delayed another 7 to 9 months. So that's actually not what we said in the last posting. What we said is that the first piece of the forensic accounting will be done by year end, and that's the high level look at how much money came in, how much money went out. That's the information we've needed to know in order to be able to work with Wells Fargo. Now, the investor by investor level piece of it is not done yet. We don't know who the net winners are. We don't know who the net losers are. And we don't know that we have a list of all investors who are involved yet until we finish going through the remainder of these bank accounts. and discover that. As you guys will see when the questionnaire comes out, there were some very interesting ways in which people invested in this scheme, and because of that, it's been a challenge, especially given that we had no records to work with. When the Department of Justice and FBI did their raids on March 3rd of 2022, all those records were seized and frozen because they could potentially attain attorney-client privilege. So we've not had access to any documents in this case whatsoever. And because of that, it's taken longer, it's cost more in order to get this done. However, we do think that this money is being spent in a way that is going to allow us to maximize the return to everybody in this case. So the time frame actually has not shifted on this forensic accounting outside of potentially a month or two. It may take us a month or two longer than we'd originally hoped because of the fact that we found more accounts, and we've had to shift gears to deal with Wells Fargo Bank and to help the SEC in producing some of these numbers. Let's see, a couple other questions came in. Let's see, regarding commissions for recommendations to friends and families, could that be counted as a promoter? Essentially anybody who made commissions, these would be false commissions because they weren't really selling a product, they were selling a scam, and so that we will seek to recover those funds. Do we know at a high level the amount of money coming in? Yes, so that money, every time we bring money into the estate, it is listed. We file an accounting every quarter. I would encourage you guys to read those accounting and the reports that we file along with the accounting that is included as part of that. Let's see. So it says, yes, recovering all the principal is rare, but the Wells Fargo case allows for recovery that is not based on the principal loss, correct? That is a legal question as to whether or not we can collect money that's outside of just principal lost, whether profits that were paid to promoters or to net winning investors could be recovered is a legal question that it has gone both directions in the past. And so we need to, that is something we will look at. But of course, we ultimately don't have a say as to how much it is that we will recover. But we will continue to fight, to get back as much money as possible. How do you figure out how much money to go after Wells Fargo for? The amount that we're going after Wells Fargo for is the amount we believe was lost by investors. And that is the number that we have sought to recover. You can pursue damages like interest above and beyond principal lost. If that happens, we seek to repay those damages versus giving the money back to the SEC. So if there is excess funds above principal, typically we will ask the court for permission to be able to distribute those funds. But again, we have to get to that point before that even becomes an issue. We will have everyone's claim. We will know what people are owed at that point. And so that if we determine that there are extra funds available, then we will look at it at that point. It says J&J supposedly has money offshore in accounts beyond the U.S. Are you aware of this, and can you recover it, or is it unrecoverable? We know of one foreign asset that is outside the jurisdiction of the United States, and that is one that we have looked at. However, we are not aware of bank accounts that are that outside the U.S. If you have any information on that, please do provide that to my staff or to me as soon as possible. We'd love to get that information so we can look at that. Money that is in foreign jurisdictions is oftentimes recoverable, but it is a process, and the earlier we get started on that, the better. So the last question, you should seek more than just the principal loss from Wells Fargo. Is that correct? Again, like I said, we will seek to recover everything that was lost by investors, but whether or not we are able to ultimately get that is a question for the court, and so we will see where that ends up going. Again, we aren't just looking at we are looking at total loss to investors based on the amount of money that they put into the case. Again, false profits aren't typically recoverable, by a third party. But again, we're going to try to get everything we can. Let's see. So I think that it says, what about the battery investment scheme is going to be part of this? Again, Eco Battery, we've already recovered on the 2 promissory notes, and we have an agreement in principle to recover the balance of the equity investment that was made. So those are all the questions I think that we'll be able to answer today. I do appreciate you guys reaching out. Anna did just post contact information in the website on the chat again, but if you do have questions, you're more than welcome to reach out to us at contact@jjconsulting-receivership.com. Again, that's contact@ jjconsulting-receivership.com. Phone number is 702-832-2299. Again, that's 702-832-2299. If you have not yet registered, I encourage you to do so. Again, that can be done on the website at jjconsulting-receivership.com. That's jjconsulting-receivership.com. I encourage you to get on there and to make sure that we know about you, know who you are. And just know that, if you think you are a net winning investor and that by not filling that out will mean that we don't know who you are, that's not true. So it's best that we know who you are and have your current information in case we need to reach out and contact you. So again, do reach out to us to let us know if you have any other information or any questions about anything that we've talked about today. Otherwise, I appreciate you guys taking the time to join the call today and look forward to talking again soon.